So we will get started. Today's webinar is Probate 102. And the point of this webinar is to dig a little bit deeper into the inventory and appraisement, because we had a good many questions on it. And also looking at the personal representative a little more, because I know people are always unsure who to leave as the personal representative. So that's going to be our main focuses today. So it'll be a little bit more in depth on those two areas. If this is your first time joining me for a webinar, I always like to give you a little bit of information about myself. I'm a graduate of the University of South Carolina in 2009 and a graduate of the University of South Carolina School of Law in 2013. My main practice areas are estate planning, Medicaid planning, and business planning. So they kind of all work together to help clients with businesses or to help individual clients with their estate plans, as well as some Medicaid planning for those clients who need that. So our outline for today is we're just going to do a quick summary from Probate 101 in case you didn't get to watch that one. Also, feel free to check out my YouTube channel, Attorney Lauren Ward, for the full presentation. So that way, if you missed it, you can go back and rewatch it whenever you want. So then we'll go over the inventory and appraisement, the personal representative, and talk about when you do need an attorney for the probate process. So getting started here now, we'll go into first kind of our refresher from Probate 101. So probate is the process by which assets are transferred from the decedent, that's the deceased individual, to his or her heirs or devisees. Heirs are if you don't have a will, these are people at law that will inherit. Devisees is if you have a will, your beneficiaries in that will. So just some quick facts about it. Probate is about a year-long process here in South Carolina. Technically 8 months is the creditor period, but in reality, from start to finish, it's going to take more like a year. The reason for that long is the creditor period. We have to put notice in the newspaper to creditors of the individual's death, and that's an 8-month period for a creditor to respond. Some other kind of facts people like to know: probate is public record. Probate is handled in the county where the decedent lived at the time of his death. And also, it's going to have to be handled anywhere the decedent owned probate real estate as well. So if you own a house here in Spartanburg County and maybe you have a beach house down in Beaufort County and they're just in your name and they're probate property, we're going to have to probate both places to make sure we get those properties properly transferred. So now we'll go into more of today's topic. We're going to discuss the inventory and appraisement. So this is a form that is required in the probate process. The inventory and appraisement has to be filed within 90 days of probate being open and being appointed the personal representative. The personal representative has this duty to complete the inventory and appraisement. Now, if you can't get it done within 90 days, there's always, you can ask for an extension and continuance. And the probate court tends to give you one of those because sometimes it is hard to get this completed in 90 days. Real quick, I'm just going to show you what the inventory and appraisement looks like. This is a copy of what you fill out with the inventory and appraisement with probate court. You can find this on sccourts.org and look at the court forms, and you'll see it in the probate court forms. It's listed as inventory and appraisement. As you see, you have different things on here you have to list: real estate, stocks and bonds, notes due and cash, insurance, if it's payable to the estate or payable to the beneficiary and it's coming through the estate, and other miscellaneous things. And you see in here, you have to go through and give a detailed description of everything. So here's real estate. So you would put the address. So say it is my office address for some reason. You put 1989 South Pine Street and put the tax map number of it. So I don't know that off the top of my head, but that's something you can find by looking it up on the county tax assessor's office as well. And then you kind of go through here, look at stocks and bonds. We look at cash, life insurance is going to go through probate. But you fill all this out and you put the percent owned by the decedent and the appraised value. And then once you do everything under each schedule, there's a total. And then you're going to bring that over here and the personal representative has to sign it. And you have to have it notarized. If you have an attorney representing you, they can fill out their information here. But I just wanted to give you a glance of what the inventory and appraisement looks like so you would know what paperwork we're talking about as we go through this. So what is the purpose of this? We just looked at it. You see you're listing the assets, you're giving the values. So we're going to list the probate assets on it because the probate court needs to know what assets the individual own individually so we can make sure the estate's properly administered and the assets are properly distributed, which is looking at section 2 right there. Property can properly be distributed. You want to have correct titles and deeds, and the probate court has to know what's there to be able to make sure we're doing the next part right and that the beneficiaries are properly inheriting their share of the estate. The probate court is going to charge you a fee based on the size of the estate, based on the inventory and appraisement as well. So normally when you first start probate, they kind of want a generalized fee, but you pay usually $20 to open the estate. But here is where they collect their main fee, is by looking at the size of the estate. So what you're listing on that inventory and appraisement is only probate property. And I think this is where a lot of people struggle with the inventory and appraisement, is knowing what should I list and not list on here and what is the value of things. So let's go through some probate property. So some examples are homes that are owned just by the individual, such as if you own your house just in your name, you don't have a spouse or any children on there, then that's going through probate. If you own your house with your spouse or family member or whoever, and you don't have the joint tenants with right of survivorship language, that house is probate property and needs to be listed. So, for example, on your deed, you have Mr. and Mrs. John and Jane Smith, and there's no Mr. and Mrs. John and Jane Smith as joint tenants with right of survivorship. That means that if Mr. John Smith passed away, his share of the house is going through probate because half the house is owned by him and half the house is owned by her, and there's no right of survivorship on there. So what you do with that is you're going to say, okay, there's a house, the value of it is $200,000. So Mr. John Smith's value in the house, he owns 50% of it. So his value is $100,000. That's with a home that's owned by a joint individual, that is owned jointly, but is not owned as right of survivorship. If the home is owned as a life estate, then you don't have to list that on the inventory and appraisement because it automatically passes at the person's death to the remainder interest. And if it's owned by a trust properly, then that doesn't go on the inventory and appraisement because it's not probate property, it's property of the trust. Bank accounts are a lot of things that run through probate, and that's if the bank account is owned by an individual with nobody else. There's no joint ownership. It is just this one person. And that bank account doesn't have a beneficiary on it. So the account isn't payable on death or transferable on death or isn't owned by a trust, then it's going to go through probate. Vehicles are very common probate property. If it is owned in just one person's name, then it's going through probate. If or is on the title, so it's Mr. or Mrs. Smith, then it's not going to go through probate and it'll automatically pass to Mrs. Smith at the death of Mr. Smith. But if it's Mr. and Mrs. Smith, then it's kind of the same thing that happens with Mr. and Mrs. Smith on the deed of the house. It means that each person pretty much owns half the car. So say the car's value is $20,000, then half of it would be $10,000, and that's going to be a probate asset, and you're going to have to list it on the inventory and appraisement, and you're going to have to deal with retitling the deed. So vehicles is a common thing that a lot of people just own in one name. That's going to be a probate asset. So if you have retirement accounts and you don't have a beneficiary, so you have that 401k and you never updated it and put your children's name on there and your spouse has passed away, then that's going to go through probate. Personal property will go through probate a lot of times. That's your household items. If you haven't already given those away and you own them at the time of your death and you own the house, then we have to look at personal property as well. Stocks and bonds that are in an individual's name. So if you own a stock and it's just in John Smith, then it's going to go through probate. If it's in John or Jane Smith, then it'll pass outside of probate. Or if it's owned by some other entity, such as a trust, it's outside of probate and you don't list it. But a lot of times that stock or bond is in an individual's name. And with bonds, you have those issued. If you look at the bond and see it's just in Mr. John Smith, you can always, while you're alive, go ahead and have that bond reissued to be put in multiple people's names. There may be some gift tax consequences of that, so it's something you always want to consider, but a bond just in an individual's name is going to go through probate as well. Real estate is the same as like your home. So you own a tract of land. What's on the deed is going to control if it's going to be listed on the inventory and appraisement. So once again, if it's one person's name or if it's Mr. and Mrs. and we don't have that right of survivorship, there's no life estate and it's not in a trust, that's going to have to be listed on the inventory and appraisement. So one thing a lot of people don't realize when they're doing this inventory and appraisement is how important it is to properly value that probate property owner. The value listed on the inventory and appraisement is what the beneficiary's value is going to be in the property. So for example, say your parents bought a house back in 1970 for $60,000. Well, that's their basis in the property. Your parents pass away, your mom's the surviving spouse, it goes to her outside of probate, but to go to you and your siblings, it's going through probate. So you're going to list that house on the inventory and appraisement, but you don't want to put that $60,000 your parents bought unless that's the actual value now. Say the value in the house is $160,000 now. So that's going to be an issue where your parents' basis in the house is very low, but yours could be very high, and we don't want to list that 60,000. And when we go to sell it, there was 100,000 we didn't account for pretty much and have to pay some capital gains. We want to make sure we get the correct basis listed. So that's why it's always important to make sure you have the proper value on that inventory and appraisement, because that's going to be your value. And that really matters for tax purposes if you go to sell property. So things to look at for real estate is having it actually, you can look at the tax map value number, but sometimes that's not always the best value to use. So there's things like getting it appraised by a certified appraiser. That is always a great way to go. It's a little more costly, but it does give you a very accurate value of the house. You can look at having a realtor give you a fair market value appraisal on what they think the house would sell for. You can look at doing things like that. For vehicles, you can look at things like the tax value. You can look at Kelley Blue Book for vehicles, as well as having it appraised. You can take it to a dealership and have them give you a quote as well. For antiques and valuable items like that, you might want to look at having it actually appraised by a professional in the industry. So it's very important that we make sure we get that right value on the inventory and appraisement for our beneficiaries. If they go to sell the property, they get the right value in it. So it is important to notice you value it at the day of the individual's death. So if you open probate 6 months later for some reason, you don't value it on the day you open probate or the day of the appraisal. You're going to have to tell the appraiser that this person died maybe January 1st, 2020. So we're going to need to evaluate it based on January 1st, 2020, not maybe June 6th when you finally got that appointment with probate. But it is very important to make sure we get those values accurate. So I had a question earlier that came up that I was sent in chat, that what if I own property, real property in other states or other counties? Do I list that on the inventory and appraisement? So this is kind of slide takes care of it. This is called ancillary administration. So the administration of a decedent's estate in a state or county other than the one in which he or she lived for the purposes of disposing of real estate. So this is important to list all property on the inventory and appraisement in case you need to file in a different jurisdiction. For example, you own that house here in Spartanburg County, but you also own that house in Beaufort. So when you go ahead and do the inventory and appraisement, you need to list the house in Spartanburg as well as the house in Beaufort under that real estate property listed on the inventory and appraisement if it is probate property. So what happens in these situations, and this is for different states as well, different counties, different states. The probate court is going to send certified copies to the other county. You have to request for them to do this usually, and there's a fee involved. So usually you pay a fee to the probate court here to make the certified copies, and you're going to pay the probate fees to the other jurisdiction within the state or within our different state. So the probate court sends it, and you have a shorter process of probate, but you do have to make sure you do this because you have to have this ancillary administration for real estate purposes, because you have to understand how the deed was conveyed and the title properly passes. So if you have property in a different state, that's when you may need to look at hiring an attorney to help you probate in that other state as well. So that kind of is our summary of the inventory and appraisement. It's a pretty complicated document that you have to fill out with all the probate assets of the individual. It does take time, and it is a lot of work on the personal representative to do this. So that's what we're going to talk about. Who do we want to have a personal representative for our estate? So real quick, a personal representative is the executor or administrator appointed by the court for the estate of a deceased person. You can list your personal representative in your will who you want to handle it. If you don't, the rules of intestacy cover who will be your personal representative. Personal representative and executor administrator are all the same terms, but
How are the Doritos?
Yes.
They're expensive when you get them there.
So that is the personal representative, kind of who they are.
Well, I'm sorry. I knew that they wouldn't have it until 12.
So we will go and talk a little bit more about the personal representative. The responsibilities are kind of the big thing people want to know about the personal representative. So yes, they're the ones dealing with the probate court. They're going to handle properly filing the probate paperwork, that inventory and appraisement, the application, the accounting, everything that the filling out the deeds, making sure they're properly filed, the distribution, everything through probate court. They are going to be the ones responsible for doing that. Once you open the probate estate, they're going to need to get a tax ID number for the probate court. For the probate estate. So that's going to the IRS website and getting that EIN number. And then they're going to need to make a bank account for the probate estate. Their duty is to protect the probate assets for the purpose of the beneficiaries or creditors. So they're there to protect the estate. They need to make sure all the probate bills are paid. So they need to be keeping a good accounting of everything they do, whether they're using QuickBooks and Excel spreadsheet. They need to have a record of everything. They're going to deal with the creditor claims that you're going to get possibly as this probate process, and they're going to distribute the assets and close the estate. So it is a lot of duties for the personal representative. So a lot of people wonder who should be my personal representative, and this isn't the easiest choice to make. So it can be a family member. A lot of people are going to list their spouse or maybe their child or children. It can be multiple people. You can have it where each person can have the independent authority to act. So maybe you have 2 children and you want to list both of them, and you give them each the individual authority to act. Or you can make them act jointly depending on the language in the will. So my usual recommendation is if you're going to have 2 people, let them act individually typically, because it makes it a lot easier on everybody so they don't constantly have to do things together. But this is not the situation for every case. Sometimes we have to look at your family dynamics to play into that. It can also be a non-interested person. It doesn't have to be your family member. Maybe you don't want to put this burden on a family member because you don't want them to have arguments having to deal with distributing the estate. So it can be a non-family member. It can be a friend, or maybe it's like a distant cousin who's not going to inherit anything, but you want to have them administer the estate. If you don't have somebody you trust to do it, it can be a corporate personal representative, such as a trust company, a bank, or other fiduciary service providers. Sometimes if you're leaving assets to a charity, you may can speak to that charity about if they will serve as a personal representative. So those are all kind of options on the personal representative side of things. I will say when you're picking a personal representative, it is a very form-driven process. There's a lot of paperwork. There's a lot of financials you have to deal with. So it's important to make sure with that you have a person who can handle the stress of all the paperwork. It's important to make sure that your person is okay dealing with money, and maybe they're not the best with money, but or they don't understand a lot, will they be willing to go deal with an accountant? Will they be willing to deal with a CPA? Will they be willing to deal with an attorney to help them? This is a large responsibility on a person, so it takes some time to think about who is the right one for your personal representative. But it does need to be somebody that can handle the stress of it, doesn't mind dealing with the probate court, and can handle the financial side of it, because you are going to need to keep records. You're going to need to know how the assets are distributed. And you may have to deal with conflict with the heirs, and sometimes that can lead to probate litigation. Hopefully, that doesn't happen in your case. I think having a good drafted will and having everything taken care of can help with that. And if you're really worried that I don't think I have a family member, that's when you can look to that corporate representative. But no, those do have a fee involved, and typically they're based on the size of the estate with a minimum fee. But there is no family conflict there because they're going to administer it in the way that they should as a corporate fiduciary, and they're not going to be a part of the family drama with it. So that is always an option to look at, or maybe you don't have family here. So that's kind of another question we got come up. So if I don't have any family members here, who should I get to be my PRs? There's different ways you can think about that. Do I want to look at a corporate PR? Is there a friend I have here that would handle it? Sometimes attorneys will be a personal representative for you in some situations, or CPAs. So you can look at those people that are part of your advisors. You can always list a person out of state, but they're probably going to need to more than likely hire somebody like an attorney here to help them, because it is a lot of paperwork they have to deal with. So that's always things to consider when you don't have any family here. So that was kind of our summary of what the PR does and a little bit more in detail. And a lot of people wonder, do I need an attorney? Well, with probate, you're not required to have an attorney for basic administration. If you're filing petitions and that type stuff, that's when an attorney comes into play. So, for instance, if you're having to do a formal probate and file a summons and petition, the personal representative probably will have to hire an attorney at that point. But sometimes the PR has some legal questions and doesn't sure on how to properly administer the estate. I think that's always a good time to look at talking to an attorney to make sure you do things correctly. Anytime the PR is dealing with deeds, we want to make sure those are done correctly. So that's a good time to consult an attorney. One big thing is when you're wanting to sell real estate, you have to file, and if it's not in the will that you can do so, you're going to have to file a petition with the probate court. So that's the time that you're going to want to talk to an attorney, because they're going to need to file that formal summons and petition for you. If you have creditor claims and you're not sure how to handle those, if they need to be paid, not paid, or you need somebody to help negotiate them with you, that's always a good time to look at an attorney too. So I think it's better to ask for help sometimes from the people that can help you the most, like attorneys, CPAs, insurance, financial advisors, because you want to make sure as the PR you're doing things properly, so that way you can properly administer the estate for the benefit of the beneficiary, since that's your job with all of this. So real quick, I always like to give you just some quick tips for avoiding probate. We can have bank accounts as joint tenants with right of survivorship or payable on death. We can have real estate owned as a life estate by a trust or joint tenants with right of survivorship. We can use a trust as a really good estate planning tool to have our assets held to avoid probate, and make sure we have beneficiaries updated on things like life insurance, 401ks, IRAs. So my final thoughts with all of this is it is important to properly list assets and their value on the inventory and appraisement. That is one of the most important duties you have, because you want to have it right for those beneficiaries, and especially for those tax purposes. You want to make sure you pick the right personal representative, because that's really important to your family when you're no longer here, to make sure that you pick that person that can handle this stress. And then sometimes you may need an attorney during certain points of the process, and sometimes you may not. It kind of depends on each probate process. So right now we got a question: how does an attorney help the executor if it's the younger sibling and the older sibling is disabled? So with having a disabled sibling and inheriting, you may need to look at having special needs trust put into place to be able to protect them to keep getting their benefits. But pretty much the executor is there. The executor is administrating, doing the whole estate. And if somebody finds this is another time you may need an attorney to help, maybe if the person that's your personal representative is not properly administering the estate, that's sometimes when you have to petition the court to be able to remove them and add somebody else as personal representative. So that's some ways attorneys can help if the personal representative isn't doing exactly what they should be doing, not following the guidelines, not doing the proper administration of the estate. And if there is a disability involved and special needs, we may need to look at these special and supplemental needs trust as part of the estate plan to make sure that that person is protected. So do we have, if we have a few more minutes, if anybody else has any other questions they would like to ask, feel free to unmute yourself and ask, or to send it to me in chat. Either way, completely fine. And if nobody has, oh, we have another question. So how much can an attorney really help during the probate process? Does using an attorney speed up the process? I think an attorney is pretty helpful in the fact that they know the paperwork, they know how to fill it out, they know what you need to do to make sure it's properly done. It sometimes can speed up the process because you may not have to make as many appointments with the probate court. They can fill in the paperwork and send it in for you, so you're not having to wait maybe that few months to get an appointment. Right now with COVID and the craziness, it is taking a while for people to even get those first appointments with the probate court. So having an attorney can help speed that up for you, so you can go ahead and send in the paperwork and get it appointed PR. But in general, it is a little slower whether you have an attorney or not right now, just due to COVID. So I think that's something we all have to keep in mind. Another question, if your deed is not joint tenants with right of survivorship, can it be amended? And the answer is yes, you have to do a new deed. So you're going to have that old deed, and you're going to need to have somebody draft a new deed for you that lists you as joint tenants with right of survivorship. So you usually do a quick claim deed to be able just to convey it. So you have Mr. and Mrs. Smith as joint tenants with right of survivorship. One thing I do mention, every time you update a deed, if you are getting that 4% residential rate, you're going to have to reapply for that. If you're getting the homestead exemption, you will have to reapply for that. Doesn't mean you're not going to get it back. It's just stuff you have to reapply for. The one thing that's a little bit more difficult is if you're getting the agricultural exemption. We may want to talk before you do anything with your deeds on that. But for usually you can easily still get that 4% in that homestead exemption, even if you do it, but you do have to reapply. Do we have any other questions from anybody? Well, I don't think we do. Feel free. My contact information is on the screen. Feel free to email me if you think of something later on. We have recorded this, and it'll be going on my YouTube channel, as well as everybody that attended will be getting the link. And I thank you all for joining us today, and please feel free to reach out to me in the future if you have any questions. And I hope you all have a great holiday season and a Merry Christmas, and we will probably be back. We probably won't have another one of these in December since the holidays will be in full force, but we will be back in January with some more videos. And sometimes I'll be uploading some stuff just to my YouTube channel, and I can send you out links to that without having the webinars. But we are here to help if you have any questions. And thank you all for joining us today.